Hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we're going to talk about a really important question. What is it, Matt?
Can I have 2 trusts? Can I have 3 trusts? Can I have 4? Do I need to have an abundance of trusts? I want more.
You want more. It's like you just want one, and then it's like, oh, I want another one, and I want another one.
Right. It's like I heard people who get tattoos. Like, they always want more.
They just crave another one.
I mean, trusts are just so addictive. It doesn't surprise me.
Well, that is a really good question. So it's basically the question of, are there multiple reasons, or are there multiple uses for trust that could not be handled within the same document?
I would say so.
Right? Because we don't want to make it complicated.
No. I hate making things complicated.
All right.
So, no, well, I mean, the answer is yes. I mean, you can have as many trusts as you like. But exactly like what you said, Kirsten, it all depends on what are your goals with estate planning.
Mhm.
And if you have a ton of different goals, if you have diverse goals, whatever, if they're able to be accomplished in one trust, great. They might not be able to be accomplished in one trust. They might need to be accomplished in 2 trusts. They might need to be accomplished in several different types of trusts. So I guess to that end, the main trusts that we work with are the revocable and the irrevocable trust, which we talk about a lot. But Kirsten's mentioned many times, under the realm of irrevocable, there's so many different types of trust. So I guess if you can talk a little bit to that, Kirsten, about the different types of irrevocable trust, why you'd want one, why you'd want another, why you'd want maybe both or all of the above.
Yes. So this is a really interesting topic, because first of all, we have to define what a revocable and an irrevocable trust is. And for those of us who have heard our workshop, you know that we talk about the open box and the closed box. So the open box is what we consider to be the revocable trust. And that's the one that gets you, if you have all of your assets inside of the revocable trust, now that gets you out of probate. And probate is a legal process that requires a lot of time and attention. It's a very good process, don't get me wrong, but a lot of times people are saying, I trust that I have people in my family, so we don't need to have the state of Wisconsin overseeing and infusing their strategies, their rules onto how we do this. We want this to be a family matter. We want to develop a trust document that is going to articulate what all the rules are. And in the revocable trust, that then gets you out of probate. So that's awesome if you want to do that. The irrevocable trust is the one that has very different language in it. And that language actually does asset protection. And as you said, there's a lot of different types of irrevocable trust. So I'm going to limit my comments to the one that provides asset protection, because when we think about a family, we think about all of their stages. So when we have clients that come in their 50s and their 60s, we're not just doing estate planning for them for the next few years. We're looking at estate planning for them for the duration of their lifetime. Similarly, somebody may even come in their 30s or their 40s, and it's important to get things set up. In fact, we just finished an estate plan with a young man who's 25 years old, and he has a large inheritance coming directly from his grandfather, which makes him the most eligible bachelor in the state of Wisconsin. And he is not interested in putting things into the asset protection irrevocable trust, but he is interested in putting everything into the revocable trust, including the house up north that his grandfather has him inheriting. Now, I said to him, well, if you get the irrevocable trust right now, you don't necessarily have to fund it, but at least you have it set up. So that then when you decide that you want to start doing some asset protecting and putting things into that irrevocable trust, it's there, it's available, and it's very simple then to move things from the revocable to the irrevocable trust. So that's what he ended up doing. So sometimes people are even setting up that irrevocable trust thinking about the future, but not necessarily funding it in today's conditions that they have.
So when we're talking about clients that have a revocable and then this asset protection irrevocable trust, I get a lot of questions to say, well, why don't I just get the asset protection irrevocable trust then? I really want to protect my assets and that avoids probate. Why don't I just get that? Why do I need that and perhaps also a revocable trust? First of all, most clients say, I didn't know I could have two. Yeah, there's no rules. You have as many as you want.
Yes.
But so they say, I didn't know I could have two. And then if they say, well, if the irrevocable trust provides more protections, why do I even need a revocable trust?
And quite frankly, there are some situations where that is all they need. So there might be, and it really depends on the assets and where the assets are parked. So if somebody has a very large 401k, as we've talked about, a 401k cannot go into a trust. So it has to kind of hang out there. The beneficiary can be the trust, but it can't go inside of a trust.
Mm-hmm.
So you've got a big IRA, and let's suppose you have not much in cash, meaning under 50,000 in cash reserves. And then you have a house and a property that you really want to protect. Let's say it's the family farm that you inherited and then another house in town. Well, that would be a perfect situation where only an irrevocable trust would be needed, because if you parked those two large assets in the irrevocable trust, now it's got that asset protection. The IRA is kind of hanging out there for use and enjoyment during retirement and maybe even end of life issues or prior to that. And then if you keep a low cash balance in your account, it will not trigger a probate if it's under $50,000. So now that client has had all of their needs met with simply an irrevocable trust. So that's a great plan. And if we can do that for people, we will. Sometimes it's only the revocable because there just aren't assets enough to protect, or believe it or not, sometimes people will have a lot of assets, like say $20 million of assets. Well, at that point in time, they're not thinking so much about asset protection relative to Medicaid, and they might not be concerned about lawsuits. And so they think to themselves, I don't really need an irrevocable trust. Let's just put everything in the revocable trust. So that might be a situation where only a revocable trust would be needed, because they feel that they're going to pay for their care anyway. There's enough income coming off of their investments that they don't need to actually dive in to the irrevocable trust world and get protections. Now, I will say this, very, very few people who have substantial assets land in that spot. But if they do, we completely respect it. But most of the time, somebody who has significant assets, they at least want some assets absolutely protected for purposes of lawsuits, for purposes of, well, what if something really terrible happens and we really are working through those funds, and we want to make sure that some things are protected no matter what.
And for the relatively insignificant cost difference between a plan with just a revocable and a plan with a revocable and the asset protection trust, most people, especially if they have those types of funds, say, yeah, it's not that much more. And this way I know, and I have that peace of mind that my home or my place up north or whatever assets I do have is going to be protected.
Correct. Now, something that we should probably add to this conversation is the issue of LLCs or corporate entities. So there are really interesting groups of businesses that you can pull into a revocable or an irrevocable trust, just depending on the business, depending how much protection you wanted to have. But then the question is, let's say I'm a small business owner and I have the business and I own the property that the business is running out of, and I also have a rental property on this in the same vicinity. Do I need to have 3 separate LLCs for that, or 3 separate business entities for those 3 separate assets? And the answer is it may be a good idea. We really have to look at the facts of your situation and decide whether or not it's a good idea to have them all in a different corporate entity and then have them all owned by a trust, whether it be the revocable or the irrevocable. So this is where, again, you can have as many corporate entities as you want. And what they do is they provide protection from the other assets. So, for
Sure.
example, if you have a property and the business is being run on the property and somebody slips and falls on the property, well, then that's a property claim. And that is only within the one LLC that has only that property. And if you've been smart about it, your business is actually inside of a separate legal entity and it cannot be liable for that slip and fall claim against the building itself. So there's an example.
Super interesting. Yeah. So we talked about the revocable, people having a revocable and the asset protection trust. In the next video, we're going to get into some more unique trusts that go into more specific situations that some people are looking for that I think would be kind of fun, and also some stories about some clients that have some of those unique trusts. So make sure you come back for that next
Yes,
video.
absolutely. Well, thank you so much for joining us. We are here for your today and your tomorrow. See you next time.